So, tell me what happened on Friday, first of all, and then tell me what that means.
Sure. On Friday, Atlantic Coast Pipeline and Dominion sued 21 or so folks in Nelson County, essentially everyone in Nelson County they don't yet have an easement with, right, for what's called quick take, which is the right to seize your property prior to you having your day in court, frankly.
So these are the remaining folks that they don't have deals with or what have you.
That's correct.
And how quickly does this process go? I mean, what is it? Does it go to a local court, a federal court? What happens?
It's all in federal court since this is federal eminent domain. So very quickly, the deal with quick take is eminent domain laws require the company to first prove that they have the right to eminent domain, which is what the Federal Energy Regulatory Commission gave them the certificate for.
Right.
Now that's still disputed, but that's their position.
Right.
And then they're supposed to pay you fair and just compensation.
Right.
If you don't agree on how much fair and just compensation is, and you can't find terms, then you go to court. Right. And so the landowners like us who've said, no, we don't either believe you have the right to take the land, nor do we believe your price is appropriate, have said, let's go to court. Well, they're now going to the court and they're saying to the courts, hey, that court date is going to be set in 2020. We don't have time to wait for that. We need to build this pipeline. So we want to take the right now to the land before due process, cut the trees, dig the trench, lay the pipe. And then we'll get to court later and argue about price.
Now, you used an analogy earlier when we talked. Yeah. Tell me about that again, how you would equate what's happening to that example.
In any contract law or any sort of negotiation, the timing is a relative issue, right? So if, for example, Tommy, you said to me, Richard, I want to buy your house. Right. And I said, sure, Tommy, I'll sell you my house. I'll sell it to you in January, and it's November now.
Right.
And then we agreed to that, but we said we need to still negotiate the price. We haven't yet agreed on the price. And I signed that deal saying, I'm going to sell you my house in January for a price to be determined.
Right.
And then you went to the court and told the court, hey, listen, he's already agreed to sell me his house. That's a foregone conclusion. It would be really convenient for me to move in now instead of in January. How about you just give me the right to take over the house right now? Right. That's the same deal, right? Timing matters. It's a substantive right in the contract. And by taking away, by giving them quick take, they basically extend the law in a way that only Congress can extend the law. Right. And secondly, they take away our right to due process. I never get my day in court until after the damage is done.
Right. What's left, Richard? I mean, in reality, what's left before this thing really begins happening?
Well, you know, it won't surprise people, but maybe it will. I'm still optimistic. There are actually a lot of things left. And that's exactly the reason why this quick take is so abusive, because there are many things that could still stop this. For example, in the Fourth Circuit, they have lost their Forest Service permits. Again, those are stayed, right, from a court of appeals. They still don't have their air quality permit. Now, they might get it on December 10th, but they might not, right? That's for the compressor station. There are constitutional cases in a number of cases. And in North Carolina just last week, they stopped eminent domain and quick take because they said, hey, look, there's all of these cases pending that could both change the course of the pipeline, but also whether it gets built or not. And so there's a lot left, and yet the way that we've been treated in Virginia courts so far is they've just rolled over for Dominion and let them come in and cut trees in advance of whatever they want.
One final thing on this quick take. Is that essentially a procedural move? Is it the court wraps a gavel and it's done, or do they actually argue the cases?
There's a hearing, and the hearing will allow for landowner and lawyer testimony. And so in our case, you asked timing earlier. They filed on Friday. We have 14 days to respond. They have 7 days to respond to our response, and a hearing day should be set. So we're probably 21 days, maybe 30 days, somewhere in there out. Obviously, the holidays are kind of in the mix, so it's a little uncertain. There'll be a hearing. Once the hearing is over, depending on the outcome of the hearing, the case will be appealed either way. But generally, precedent is they'd get quick take, and then they'd be able to start cutting trees right